Hey guys, today we're going to talk about usurping business opportunities by directors of companies in the context of directors' duties. Now, a director cannot obtain for himself any property or business advantage that belongs to a company or for which he is negotiating. A director cannot also divert a corporate opportunity to a competing company. It is a clear breach of duty for a director to set up a competing company to take advantage of a contract that should have gone to the company of which is a director. Let me discuss the case of Cooks and Deeks, which was a Privy Council appeal from Canada. The Toronto Construction Company had 4 directors who were also shareholders. The Toronto Construction Company had previously entered into contract with the Canadian Pacific Railway to lay railway lines. The defendant directors of the Toronto Construction Company entered into negotiations with Canadian Pacific Railway for the award of another contract to lay railway lines without the plaintiff's knowledge. That means Toronto Construction Company, even though one of the plaintiffs was a general manager. So when it was clear that Canadian Pacific Railways would award the contract to the 2 defendant directors, the 2 defendant directors set up a new company to undertake the project. So of course the plaintiff sued, and the Privy Council held that the contract belonged in equity to Toronto Construction Company, and the directors were in breach of their fiduciary duties and had to account for the profits made, for the loss of profits that went to the company that the directors created, which entered in a contract with Canadian Pacific Railway. It is important to note that this obligation of not usurping business opportunities persists even after a director has resigned from the company, or at least when the resignation is prompted by a wish or desire to obtain a property for himself. I'll now discuss the case of Canadian Aero Services and Malley, which is a decision of the Supreme Court of Canada. The defendants were senior officers of Aero, which was interested in obtaining some contracts for a project. So there were initial negotiations for the contract conducted by the defendant directors. Now, the defendant directors of Aero later set up another company called Terror and resigned from Aero while the negotiation was still in progress. Terror then subsequently bid for the contract and obtained the contract. Now, the Canadian Supreme Court held that they had to pay damages. The defendant directors who negotiated the contracts had to pay damages to Aero as they breached their fiduciary duties. The court held that they had an obligation to pursue the contract on Aero's behalf, but instead took it over for themselves in the new company Terror. And the fact that they resigned from Aero was irrelevant to the issue of whether they had breached the director's duty, as the resignation was prompted by a desire to obtain the contract. The fact that the company could not itself succeed in getting the property or the business opportunity is irrelevant. This was laid down in the English High Court case of IDC and Cooley. Now, Cooley was the managing director of IDC. IDC wanted to get contracts from Eastern Gas Board, but Eastern Gas Board was not satisfied with IDC's setup. The Cooley was the managing director of IDC, and Eastern Gas Board refused to give IDC the contracts. Eastern Gas Board later approached Cooley, who's the managing director of IDC, and invited him to be a project manager for one of the projects. As you can expect, instead of disclosing this to IDC, Cooley resigned and accepted the post for one of his projects. So the court found that even though IDC could not have obtained the contract, he breached his duty to IDC and had to account for the profits made. The other case I'm going to talk about is the case of Queensland Mines and Hudson, which was a Privy Council appeal from the High Court of New South Wales. The Privy Council in that case held that if the company is fully aware of the director's intention to take up the business opportunity which the company has rejected, then the director is not in breach of his duty. Whether or not there was a waiver by the company of the duty not to usurp business opportunities is dependent on the particular circumstances of the case. But as a general rule, it is always best for the director to disclose to the company if he wants to take up a rejected business opportunity, and to get the board and shareholders' approval before taking up the rejected business opportunity. So thanks for watching this video on usurping business opportunities by directors.